passed. Banking Amendment Bill 2025.
CC Government Motion, proposed resolution under Article 73(7) of the Basic Law and Section 7A of the Hong Kong Court of Final Appeal Ordinance relating to the appointment of a judge of the Hong Kong Court of Final Appeal from another common law jurisdiction. Members who wish to speak, please press the Request to Speak button. I now call upon the Chief Secretary to speak and move the motion. President, I move that the resolution under my name, as printed in the agenda, be passed. That is, this Council endorses the appointment of the Honourable Sir William Gillow Gibbs Austin Young, KNZM-KC, as a non-permanent judge from another common law jurisdiction of the Court of Final Appeal. The CFA is the final appellate court in Hong Kong, hearing both civil and criminal appeals. According to the Hong Kong Court of Final Appeal Ordinance, the CFA consists of the Chief Justice and the permanent judges. Non-permanent judges may be invited to sit, and they may come from Hong Kong or other common law jurisdictions. When hearing and determining appeals, the CFA is constituted by 5 judges, comprising the Chief Justice or CJ, 3 permanent judges, and 1 non-permanent Hong Kong judge, or HKNPJ, or 1 CLNPJ. Article 88 of the Basic Law provides that judges of the courts of the Hong Kong SAR shall be appointed by the Chief Executive on the recommendation of an independent commission composed of local judges, persons from the legal profession, and eminent persons from other sectors. The Judicial Officers Recommendation Commission, or JORC, is the statutory body constituted by the Judicial Officers Recommendation Commission Ordinance to perform the functions of the Independent Commission referred to in Article 88 of the Basic Law. Pursuant to Article 92 of the Basic Law, judges of the Hong Kong SAR shall be chosen on the basis of their judicial and professional qualities and may be recruited from other common law jurisdictions. In the case of the appointment of judges of the CFA, Article 90 of the Basic Law provides that the Chief Executive shall, in addition to following the procedures prescribed in Article 88 of the Basic Law, obtain the endorsement of the Legislative Council and report such appointments to the Standing Committee of the National People's Congress for the record. The arrangement of appointment of CLNPJs by the HKSAR, as authorized under the Basic Law, enables Hong Kong to maintain close ties with other common law jurisdictions, which helps maintain a high degree of confidence in the Hong Kong SAR's judicial system from the international community. Having continuously appointed top-notch overseas judges who are internationally renowned and with rich judicial experience as non-permanent judges of the CFA, is a unique advantage of Hong Kong SAR's judicial system, which manifests the protection to exercise independent judicial power in accordance with the law by the Hong Kong SAR judiciary as enshrined in the Basic Law. At present, the CFA has 9 non-permanent judges, comprising 4 HKNPJs and 5 CLNPJs. All of the CLNPJs have extensive professional commitments themselves, including arbitration, mediation, and lecturing work. In addition, most of the judges have expertise in different areas of law. Hence, appointing more CLNPJs with different expertise helped the CFA handle different cases more effectively and flexibly, thereby ensuring the court's effective operation. The JORC has recommended to the Chief Executive the current appointment of Sir William Young as a CLNPJ for a term of 3 years. Sir William Young is a judge of eminent standing and reputation. His practice covered a wide range of areas, including crime, competition law, and tax cases. Sir William Young had been appointed as a permanent judge of the Supreme Court of New Zealand from 2010 until his retirement in April 2022. During his tenure at the Supreme Court, Sir William Young was the chair of the Royal Commission of Inquiry into the terrorist attack on 2 Christchurch mosques in New Zealand on the 15th of March 2019. Since his retirement, Sir William Young has sat on the final appellate courts of Seychelles, Samoa, and Fiji. His appointment will make a significant contribution to the CFA. In accordance with the procedures previously endorsed by the House Committee of HKCFA, the government has informed the House Committee on the 8th of May this year that the Chief Executive had accepted the recommendation of the JORC on the appointment of Sir William Young as a CLNJP. Subject to the endorsements of this Council, the appointment is expected to take effect within June 2025. President, under the constitutional arrangement of one country, two systems, Hong Kong is the only common law jurisdiction in our country and the only Chinese-English bilingual common law jurisdiction in the world. According to the 2024 World Justice Project Rule of Law Index, Hong Kong was placed 23rd out of 142 countries and jurisdictions globally, remaining in a high position and continued to be ahead of some European and American countries. Having these eminent overseas judges with extensive judicial experience constituting part of our Court of Final Appeal is truly rare among common law jurisdictions in the world. This not only fully demonstrates the distinctive advantage of Hong Kong's highly internationalized judicial system, but is also crucial to maintaining Hong Kong's unique status as a common law jurisdiction of high standard. I invite members to endorse the appointment. Thank you, President.
I now propose the question to you that the Chief Secretary's motion be passed. Mr. Lam San Kong. Thank you, Madam Deputy. I speak in support of the appointment of a non-permanent judge of the CFA. Well, we have seen how Hong Kong has excelled in the rule of law with the basic law as well as one country, two systems. The Hong Kong courts are renowned for their independence, transparency, as well as efficiency. This is an important cornerstone of Hong Kong. It provides a solid foundation for the prosperity and stability of Hong Kong. Over the years, we have been engaging overseas non-permanent judges. Their appointment brings in rich legal experience and expertise, enabling the CFA to handle complicated cases. The arrangement has strengthened Hong Kong as a high-level common law jurisdiction. This will boost the confidence of overseas investors. However, some Western media has made political coverage on non-permanent judges in Hong Kong. They may even exert pressure on them, asking them to refuse a possible appointment or ask them to resign. People who have any rationality will think these allegations and these coverage is absurd. The judges have been working for the rule of law in Hong Kong. There are also doubts about the remuneration of overseas non-permanent judges, saying that they are too high. What I know is that the remuneration and salary of overseas non-permanent judges are actually practical, keeping the offer competitiveness. They are paid on a daily basis. Flights and accommodation is settled upon agreement. The priority is for the judges to perform their duties. In addition to the pay during the specified period, they receive no other benefits. Mr. Justice Young is a judge in the Supreme Court of New Zealand. He has also served in other jurisdictions in their final appellate courts. His expertise covers competition laws, tax, and other areas. I'm sure he will make contributions to a high standard of rule of law. He will also defend the future development of Hong Kong. Mr. Dennis Leung. I speak in support of the appointment under Article 73, Bracket 7 of the Basic Law and Section 7A of the Hong Kong Court of Final Appeal Ordinance relating to the appointment of a judge in the CFA. Well, we have core competence, core competitiveness. The appointment of non-permanent judges from other common law jurisdictions is a good arrangement. It shows that we have judicial independence as enshrined in the Basic Law. The appointment of non-permanent judges from other common law jurisdictions is a well-established practice. It will enhance credibility in the international community. Non-permanent judges participate in the CFA. In 2020, there was a judicial review handled by the CFA. Lord Hoffman was a part of the panel. This enhances the implementation of the judgment. Non-permanent judges from overseas jurisdictions will bring in their individual perspectives from other jurisdictions. It also enhances the confidence of the business sector. There is importance attached to our judicial independence. According to an annual survey, about 84% of overseas companies take into account judicial independence in their corporate decisions. Permanent judges in Hong Kong work with overseas non-permanent judges. These arrangements will help groom a pool of talents. This also enhances our constitutional order. Under the Basic Law, we are allowed to draw in experience from other common law jurisdictions. In 2022 March, there was an appointment of a retired judge. He made a statement saying that he would continue. This is a critical time. They all agree that we need that support to maintain the rule of law. They also said that they accept the independence of the CFA. Their participation in the work of the CFA is fully in line with Hong Kong's interests. So this arrangement is credible and reliable. Judges rule by the law. The system itself will not affect the system of Hong Kong. The selection process is vigorous. It's a recommendation from the JORC. It has to be appointed by the Chief Executive with the endorsement of the LegCo. There is no political influence. Sir William Young has a Doctor of Philosophy in Cambridge University. He's practiced in New Zealand. He's been sitting in the Supreme Court of New Zealand. And he's also served in other appellate courts in other jurisdictions. Madam Deputy, under one country, two systems, we continue with the common law system. We need to keep the system alive. Appointment of overseas non-permanent judges is a caliber installed in our system. It will calibrate our system with that of the international community. This protects our entire population of 7.5 million. This is also a bridge for Hong Kong to participate in the international community. We need to have a good understanding of our rule of law system. We need to uphold this brilliant design. I so speak. Mr. Junis Ho. I speak in support of this proposed resolution to appoint Sir William Young as a non-permanent judge or from other common law jurisdiction. I support this proposal because this is done in accordance with the basic law. We can invite judges from another common law jurisdiction to participate in a legal judiciary system. From 1997 till now, that is 2025, it's been 28 years. Some people still have the mentality of people under the colonial rule. They have an attitude of a servitude. There are 68 to 80 common law jurisdictions. Under Article 82 of the Basic Law, we may invite judges from other common law jurisdictions, not just judges from the UK, Australia, New Zealand, and until recent years, and in recent days, Canada. We see very clearly that the situation has changed. No matter how well you treat the others, they may turn and bite you. Well, there has been at one point 14 to 15 overseas non-permanent judges, but now we have 9 non-permanent judges, 4 from Hong Kong and 5 overseas non-permanent judges. At the peak, there were about 13. Recently, French an overseas non-permanent judge resigned. We have judicial independence, but they may claim that we have judicial independence, free from political influence, but we see people resigning and leaving our system. Should we liberate our minds? Don't just confine ourselves to UK, Australia, New Zealand. What about Cayman Islands, Bermuda, Malaysia, BVI, South Africa, Singapore, Brunei, or even India? There are brilliant lawyers practicing in India. They have joined the judiciary in Hong Kong and ended up serving as judges. There are about 60 to 80 common law jurisdictions in the world. How come over the years we've only picked from 3 or 4 jurisdictions? We need to choose from all common law jurisdictions. We need to open our minds. We have to select from a wider selection so that we will continue to bloom as a common law jurisdiction. I so submit.
Dr. Simon Lee. Thank you, Deputy President. I very much welcome the appointment of Sir William Young as the non-permanent judge in Hong Kong. Back when the Basic Law was being drafted, there was Article 82 of the Basic Law, which states that the Court of Final Appeal may, as required, invite judges from other common law jurisdictions to sit on the Court of Final Appeal. This upholds the common law spirit, and this also shows that under one country, two systems, we are open to the international world. This shows that there is a seamless connection between the common law system as well as the international law system. Since the handover of Hong Kong, there have been a large number of non-permanent judges from overseas taking part in the judiciary work in Hong Kong, like Sir William Young from New Zealand. He is very experienced in the common law system. His participation in the legal system in Hong Kong would definitely enhance the credibility of our common law system. Our common law system has been renowned in the world. However, in recent years, because of geopolitics, we have been smeared a number of times by the US. There have been unreasonable sanctions against judges in Hong Kong. This appointment of Sir William Young shows that we stringently abide by the basic law, and on this basis, we ensure that the judiciary in Hong Kong has been upheld and protected, and we have the confidence of the international community. With this appointment, we will be able to be more closely connected with the other common law systems in the world. I welcome the joining of Sir William Young. I so submit.
Does any other member wish to speak? Mr. Paul J.
都接近10
We have experienced a number of such debates, and it's not that I have any new perspectives, and I'm not going to repeat them here. Dr. Junius Ho, every time he expresses his point of views about appointing judges other than from the Five Eyes countries, this is not my first time that I hold contrary views from Dr. Junius Ho. Well, he said that we should not follow the same practice. Well, I think as long as it is a good idea, we can follow the same tradition. Barristers in Hong Kong have spent a long time on studying the judgments made by judges in Hong Kong. In the past, we only had 1 to 2 pages of judgments from judges, and now we have judgments that look like theses. There are pros and cons to that. Judgments or rulings made by higher courts, well, in the UK or in Australia, for cases that concern human rights, we look at rulings made by European courts. We also look at judgments made by the US courts. I rarely look at judgments made in India, and also very few from Singapore, not to mention small common law jurisdictions in Latin America or in island countries. Well, there are judgments that we look at from these countries, but we really just look at them when there are appeals. I look at quality judgments. I don't look at the jurisdiction itself. Just now, Mr. Dennis Leung mentioned about the advantages of a common law system. We do everything for a purpose. If we fail to meet the purpose because of some political reasons, and we deviate from the original direction, and we give up on the great tradition, then this is not in line with why we invite overseas judges to sit on the CFA in Hong Kong. We should not make changes for the sake of it. We should keep the great tradition of our common law system. We should keep the relevance in order to ensure the smooth and continuous development of our common law system. We have to ensure that we're able to keep the culture and the so-called lifeline. I understand that it doesn't feel right to be sanctioned against others. There must be grievances. I have been a lawyer for years, and there are many wrong criticisms or comments on Hong Kong, and some people have been giving us a hard time for no reason. I think we should not destroy our tradition. We should not take forward reforms just for the sake of it. We should not play our hands on the enemies. We should not just follow what others do. I cannot agree. I cannot agree with what Dr. Junius Ho said, but I definitely agree with the appointment.
If no other member wish to speak, I now call upon the Chief Secretary for Administration to reply, then the debate will come to a close. Chief Secretary. Deputy President, I give my heartfelt thanks to the 5 members who have spoken in support of the appointment and also for the invaluable views. Under one country, two systems, the Hong Kong SAR is the only common law jurisdiction in the country. It is also the only Chinese-English bilingual common law jurisdiction in the world. These are unique advantages that we must keep. Last Friday, Mr. Wang Yi, Politburo member and the Minister of Foreign Affairs, together with 31 representatives from other countries, signed the Convention on the Establishment of the International Organization for Mediation in Hong Kong. It shows the international community's confidence in our judicial system and our unique advantages. We must treasure the advantage. Eminent judges from other common law jurisdictions coming to Hong Kong to serve as non-permanent judge, this is another vote of confidence in our legal system. Participation of overseas jurists in the Court of Final Appeals work. This mechanism highlights the uniqueness of Hong Kong's judicial system under one country, two systems. It helps maintain the international reputation of the Court of Final Appeal and also enhance our communication with other common law jurisdictions. Among the substantive appeal cases heard by the Court of Final Appeal, they all involve important legal point of views and also a wide area of law. CLNPJs have their own expertise and are experts in various areas of law. They are all of eminent standing, and their involvement in the Court of Final Appeals work is of utmost importance. Since the establishment of the Hong Kong SAR, the Court of Final Appeal has dealt with 770 substantive cases. Many of the rulings have become authoritative precedents in common law jurisdiction in the world. These achievements highlight the outstanding capability of our local judges and also the important contributions made by CLNPJs. I thank Mr. Dr. Junius Ho for his view. He thinks that the JORC should consider recommending more judges from more common law jurisdictions. All along, according to the basic law, we have been appointing NPJs from other common law jurisdictions according to the judicial and professional qualities of the jurist. Now, in the Court of Final Appeal, there are 2 CLNPJs from the UK and 3 from Australia. There are the top experts in the relevant legal area. They are of tremendous experience and enjoys the highest standing in their jurisdictions with proven track record. They are very eminent retired judges. The jurisdictions that these CLNPJs served are common law jurisdictions with a very similar legal system with Hong Kong. In the future, if there are other suitable candidates from other common law jurisdictions, the JORC will also consider recommending them. This is in alignment with what Mr. Paul Jie has said. As mentioned by Mr. Ambrose Lam and Dr. Hui Simon Lee, many judges have been subject to interference from other jurisdictions. Now, we strongly condemn these uncivilized behaviors. Now, MPJs are protected by our judicial system. Their independent judicial power is not to be interfered with. Now, we support judges to exercise judicial independence according to the law. We have the highest confidence in the ethical conduct and the integrity of the jurist. All judicial officers will stringently follow the legal principles and uphold judicial justice fearlessly. President, the Hong Kong Court of Final Appeal will continue to appoint eminent overseas jurists to act as CRMPJs and participate in its judicial work. It will enhance our highly internationalized unique advantages and also maintaining the international community's high confidence in our judicial system. Sir William Young is an eminent judge in the legal sector. He has served at prominent positions at various jurisdictions. His professional achievements and reputations are beyond doubt. The Hong Kong SAR government supports the recommendation made by the GRRC. This will ensure that our team of CRNPJs becomes stronger and maintain the high standard of our Court of Final Appeal. I implore members to support the appointment. I now put the question to you that the Chief Secretary's motion be passed. Would those in favour please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority of the members present. I declare the motion passed. Members' motion with no legislative effect. Mr. Kisson Young's motion on reviewing the development strategy